Okay, thank you everyone for coming. This is the Federalist Society gathering to discuss antitrust enforcement as regulation. My name is Scott Kieff. I'm a law professor at GW here in town and a senior fellow out at Stanford University's Hoover Institution. We have a great group of panelists who are going to engage in a discussion and a debate. I will try to moderate so that passions don't get too high, but we'll, of course, encourage a lot of crosstalk. We're going to go in order of the speakers as seated. Let me briefly, if I may, introduce the speakers. Our first speaker will be Robert Skital, who is a partner at the Drinker, Biddle, and Reath firm. He works on a range of antitrust issues and has a great client list. I was noticing he's done some work with technology-oriented companies like HP and Agilent and ABB. But I also noticed, of course, that he has been doing work with the Stroh Brewing Company, and drinks afterwards are, I guess, on him. Our second speaker is Mr. Jim Miller. Mr. Miller's former director of the Office of Management and Budget, is at the Husch Blackwell firm, and Jim is a fellow of mine at Hoover, so it's always great to have a fellow. Next we have Rick Rule. Many of you know Rick. Of course, he's a partner at the Cadwalader firm in New York and has been running their antitrust practice. He's also done some very low-profile work in the antitrust field with cases involving companies you never heard of, like Microsoft and ExxonMobil, and short matters. They don't even last barely a decade sometimes. Of course, last but not least, we have Ron Cass. Ron, in addition to having been a law professor and law school dean, was vice chair and commissioner of the ITC and has spent a great many years wrestling with a range of competition law issues. So we're going to begin with each of the speakers taking 8 to 10 minutes, and then we'll get some crosstalk. So if we could please start with Mr. Bob Skitol, please.
Thank you, Scott. I'm delighted to be here. If this is a debate, I think the key issue in a nutshell is whether antitrust enforcement during the Obama years has somehow moved so aggressively that it has morphed into some sort of bad regulation. And on that proposition, I dissent. I don't believe there's any reasonable grounds to support a concern of that sort. The Obama agencies have managed their enforcement agendas in a manner consistent with the Reagan through Bush to bipartisan consensus on sound and desirable antitrust policy objectives as it has prevailed throughout the past 30 years. While, as I will discuss, there are some instances where Obama agency remedies have been quite regulatory in nature, and that needs to be acknowledged and recognized. They are examples of thoughtful efforts to find middle ground in addressing new challenges in dynamic sectors of the economy, much as did a number of other administrations in the recent past. There are three parts to the antitrust story: cartels, mergers, and exclusionary conduct by dominant firms. Let's take each of those areas by itself. In cartel enforcement, the Obama DOJ has indeed been exceptionally aggressive. It has prosecuted more and more global price-fixing conspiracies, bagging several dozen guilty pleas, extracting several hundreds of millions of dollars in fines and record prison sentences. To the best of my knowledge, though, I think even the most diehard Chicago school adherents and Adam Smith fans would agree that these kinds of naked cartels are unambiguously harmful to the economy, and so they applaud aggressive enforcement in that area. Merger enforcement has been more controversial, but here again, the Obama administration has not departed in any material way from the standards governing horizontal merger enforcement since Bill Baxter orchestrated the adoption of new merger guidelines early in the Reagan administration. The Obama agencies adopted new merger guidelines 2 years ago, but they are fully consistent, at least in all material respects, with the Bush II agency's 2006 merger guidelines commentary document. The fundamental tenet of merger enforcement policy, from the Baxter guidelines of 1982 through the Obama guidelines of 2010 and their implementation to the present day, is that the agency should challenge only those mergers that present an appreciable danger of creating or increasing market power or facilitating its exercise. And under that standard, the Reagan agencies challenged mergers that would have reduced the number of competing suppliers in a market from 6 to 5 and from 5 to 4. All of the mergers challenged by the Obama agencies in the last 3 years would have reduced the number of competing suppliers in a market from either 4 to 3 or 3 to 2 or 2 to 1, and most of them in the latter two categories. I do not believe there is any such merger challenged over the last 3 years that would not have also been challenged under the 1982 Baxter guidelines. Couple separate words about vertical merger enforcement. There are two major vertical merger transactions that the Obama DOJ cleared subject to what must be recognized as highly regulatory consent decrees: Comcast's acquisition of NBC and Google's acquisition of ITA Software. After wide-ranging investigations, DOJ determined that the Comcast-NBC merger would create in the merged enterprise the ability and incentive to foreclose competition in online video distribution by denying independent distributors access to NBC content, and that Google ITA would create in the merged entity the ability and incentive to foreclose competition in online travel site by denying independent travel sites access to ITA software. Now, there's nothing novel about this theory of vertical merger violation. The Bush II DOJ invoked the very same theory in 2002 to challenge a merger between a major supplier of defense satellite systems and a major supplier of payloads for them. That's the Northrop Grumman acquisition of TRW. And on this theory, the Obama administration could have litigated to kill the Comcast and Google transactions altogether. Instead, DOJ negotiated settlements under which the parties could achieve the efficiencies driving the deals forward while assuring their competitors access to inputs essential to their business on decree-specified reasonable and non-discriminatory terms, with an arbitration mechanism to resolve any disputes about those terms. This is very similar to the settlement that the Bush II DOJ architected in Northrop TRW. Now, critics have labeled these settlements as regulation by consent decree, and while that may be an accurate label for them, that does not mean DOJ overreached. I think DOJ deserves credit for experimenting with a middle course between the opposite extremes of fighting to stop those mergers altogether and allowing them to proceed with no protection against exclusionary conduct that the transactions clearly enabled and incented. I think a close cousin to those examples of regulation by consent decree is what might be called regulation by closing statement. And here I'm referring to last month's DOJ explanation a 6-page explanation of its decision to close investigations into 3 closely followed transactions involving wireless device patents. The Google acquisition of Motorola Mobility, the main value of which was Motorola's huge patent portfolio, the joint acquisition of Nortel's patent portfolio by Microsoft, Apple, and Research in Motion, and the acquisition of Novell patents by Apple. In each case, the acquisition included a lot of so-called standards essential patents, SEPs, patents on technologies that were built into what were intended to be open industry standards in reliance upon the patent owner's commitments to license all interested parties on reasonable and non-discriminatory terms, so-called RAND commitments. DOJ cleared all 3 transactions, but used the closing statement to highlight its concern that any failure of these new owners of the SEP patents to abide by the previous owner's brand commitments could bring about exclusionary effects. In essence, the deals were cleared subject to or conditioned upon continued wide access to the patents in question. Do I just have a minute left? Well, then I'll skip over a lot of my remarks in the area of exclusionary conduct by dominant firms. Most of the attention has the FTC action and consent order against Intel has gotten a lot of attention as establishing a pretty regulatory regime to prevent continuation of the Intel exclusionary conduct that enabled it to maintain its monopoly over computer processors. But really, if you look at what prior administrations did, there's really the conduct that enabled AT&T up through the 70s to maintain monopoly in communications markets was resolved by a Reagan administration regulatory settlement that looks very much like the Obama Intel settlement. And the same practices that nailed Intel were at issue with Microsoft in the 90s and resulted in a consent decree that the Bush II DOJ engineered in 2002 that also again could be called a regulatory regime, but it's the FTC consent order against Intel is not materially different in the regulatory nature of it than the AT&T decree or the Microsoft decree. And is my time really up?
If you want to take one more moment.
Well, let's see what I skipped.
Not an invitation to.
Well, I think the bottom line is simply that the fact that the remedy adopted for any competitive conduct or potentially any competitive transaction has regulatory elements to it does not mean it's bad, overreaching, or anti-market in any sense, and certainly cannot be considered anti-business or anti-innovation in any general sense, because in each of the instances, each of the cases we've talked about in the last couple of minutes, there were smaller competitors that were enabled to grow and innovate as a result of the antitrust remedy.
Thank you. Thank you very much, Bob. If we could all just join me in thanking Bob quickly. And now if we may turn next to the Honorable Jim Miller.
Thank you, Scott. Thank you, Federalist Society, for holding this event, and I'm honored to be a member of this distinguished panel. I'd like to put a disclaimer out there. I'm a consultant or advisor to Google on their antitrust issues. but what I say today is my own, shouldn't hold Google or anybody else responsible. Also, in the interest of full disclosure, the day the stock market collapsed in 1987, I was in this very room at noontime giving an address on transportation policy. And when I left, I was dragooned by CNN and some of the other press about the stock market, and I said, oh, surely reason will prevail and the market will recover fully in just a very short time. In fact, it had already recovered from about a low of 135 to 120 or something like that. Of course, as you know, it fell precipitously from there. Alan Greenspan got on an airplane to go down to speak to the American Bankers Association in Dallas that day, and he got off the airplane. He was met by people from the Dallas Fed, and he asked, where did the stock market close? The young woman said, down 508. He said, good. He thought she meant down 50.8 points. Well, I'd like to address the question really posed by this conference: is antitrust regulation, or can it be used as regulation? In 1974 and 1975, I was a senior staffer at the Council of Economic Advisors, and at the time working for Alan Greenspan. For the 1975 Economic Report of the President, I drafted a chapter on regulation, and I included in regulation both the Department of Justice Antitrust Division and the FTC. Drafts of the report, including the chapter on regulation, went around to the relevant agencies, and what we received back from DOJ and from FTC was, we are not a regulatory agency, we are a law enforcement agency. I submit that there's not a difference, that antitrust is a regulatory event, and in fact it's even more so today. Public antitrust enforcement can have great influence on the progress or regress of an industry as well as its composition. A lawsuit, especially from government with deep pockets, can divert a firm's resources and constrain its efforts to innovate and introduce new products. The mere threat of a lawsuit can have similar results. Even an investigation, especially when prompted by competitors, and most especially when supported on the Hill by members of Congress, can have the same results. In short, wielded with effect and with prior design, antitrust policy may be used to orchestrate what used to be called industrial policy over a broad segment of the American economy. And we all know how well industrial policy fared through the years in developed countries. Recall the Japanese superstate? Despite forecasts that Japan would overtake America imminently, that in fact did not happen. In fact, upon inspection, most of the industries the Japanese government championed, such as shipbuilding and steel, fell flat, faded from view. And those that opposed, such as automobiles and electronics, succeeded spectacularly. The lesson is that if the free market, that is the amalgam of consumers, is allowed to choose, they will make better choices, even though at the time our tax, monetary, and international policies may not be the best. My particular concern here is that those in the administration and those in Congress who have tried without success to secure control over the internet and other aspects of the IT space may be accomplishing their objectives either de facto or by design through antitrust policy. Just consider the array of antitrust cases, investigations, and rumors of investigations. Google is being investigated by the FTC and its search engine and Google+. Apple and 5 publishers, are rumored to be under investigation for price fixing of ebooks. It's safe to say that the DOJ investigation of Microsoft put that company back several years. Control of the IT space is not limited to antitrust, but patents as well. Microsoft has complained that to the EU that Google, Motorola are misusing patents. Google has complained to Microsoft that Microsoft, Oracle, Apple, and others are attacking Android with bogus patent suits. And don't forget that in Congress there was an immense fight over so-called net neutrality, and that SOPA and PIPA are still kicking. Of course, there's something to the notion that antitrust authorities should not stand by when companies violate the antitrust laws. I have two comments on that. And I'm glad to see that a number of my former colleagues in the Reagan administration, Ford, Nixon administration, even Nixon administration are here. They may have some different views. First, so much of what we're talking about here is not clear-cut. The alleged violations of the IT space are based on theories that are out of the mainstream and are not at all certain to sustain judicial challenge. And in cases where there is little reason to believe that the alleged perpetrators knew or should have known they were violating the law, for the antitrust authorities to take precipitous action is to cast a pall over all entrepreneurial activities in that and similar industries. Second, even in cases where the violations are reasonably clear-cut, there is still the matter of prosecutorial discretion, and an intelligent choice would be based on benefit-cost tests with competition and thus consumer welfare being not successful litigation being the objective. I mean, you remember we could always bring Robinson Prattman case to the FTC, but it didn't make any sense. In conclusion, I'm going to finish up, you see. In conclusion, the latest focus of public antitrust activity, the IT space, is clearly the most dynamic, competitive area of our economy. Quality-adjusted prices are falling at a fantastic rate. New improved hardware and software are being introduced at rates that take your breath away. The churning that we experience or are experiencing in that industry is exactly what Joseph Schumpeter had in mind by the term creative destruction. Right? Creative destruction.
That's right.
Got it.
Although destructive creation.
Destructive creation.
To it.
But that would be wrong. I mean, so for the U.S. government to impose its discipline on the market through antitrust policy would not only be misguided, it could very well make one of America's leading industries one of the world's laggards. Thank you very much.
Thank you very much, Jim. And our next distinguished speaker is the Honorable Charles Rick Rule. Rick, please take it away.
Thank you. Thanks for inviting me. It's a pleasure to be here always with the Federalist Society. And I particularly appreciate following Jim, who was a colleague in the Reagan administration. And perhaps not surprisingly, there's a lot that I think Jim and I agree with, and I think there may be a little difference in terms of the implications, though, of many of the things that that Jim spoke about. The way this was set up, the idea, I think, was that Bob would go and present one point, Jim would respond, I'd present sort of a follow-up to Bob, and then Ron would respond. But I just want to make it clear to all of you fellow Republicans out there, I'm not here to defend the Obama antitrust administration's record. And there are, I think there are some aspects of it that that are too regulatory. I think there are some cases that have expanded into areas that I question whether they could sustain those positions in court, and I think that not going to court creates some problems that I'll discuss. And I think the criminal enforcement program, even though I'm a strong believer in appropriate criminal enforcement, I think that because of some innovations, which is basically the amnesty program, I think there have been some problems introduced into the system that are creating issues. And finally, I think I'm not altogether comfortable with what seems to be a proclivity for seeking behavioral fixes. But I'm not really here to discuss their policies or, frankly, their predecessors' policy. Rather, the question is antitrust regulation? And I agree 100% with Jim. It is. It's a specialized form of regulation, but anytime, Congress enacts legislations pursuant to the Interstate Commerce Clause, you kind of got to say it's regulation. And so, yes, it is. It's specialized in this day and age talking about regulation because it's really, when done best, administered by the courts, by a non-specialized, if you will, administrative body. And it applies across a broad number of different agencies. And so that means that it has special aspects that folks have to take into account. I'll talk about that. But over time, I think, one can point to, for example, the FTC Act, more recently the Hart-Scott-Rodino Act. Also, I think the rise of other jurisdictions where it's more clearly a regulatory regime like the EU, that enforcers have come to view themselves more as regulators than enforcers. And I think that is a bad trend. I gave a speech in 1984 when I was in the Antitrust Division where I basically talked about antitrust as regulation and deregulating antitrust. And I will say that I probably got more comments, and they were not positive comments, from the antitrust bar about that speech than any other speech I ever gave there or thereafter, because antitrust lawyers don't like to think of themselves as being regulators, but they are. And I think you need to explicitly acknowledge that, particularly if you're running an antitrust agency, because you have to structure your enforcement policy and really the rules, and courts need to understand this, in a way that takes account of the various potential error costs, costs of enforcement, costs of deterring pro-competitive behavior when creating the rules and applying the rules. And I think you can look no further than the Supreme Court today, and since the speech I gave in '84, and the Trinko decision, where the court sort of acknowledged that explicitly. So having recognized that antitrust is regulation, what are the implications? Well, there are two ways you can go. I mean, one, and I may be the only person up here who's ever suggested that we ought to go down this road partially. One is to start getting rid of some of the antitrust rules and some of the antitrust institutions. I don't know whether this is known, but in the last part of the Reagan administration, I suggested to my counterpart at the FTC, Jim was gone at that time, that we do away with the FTC. This is in the days of Graham-Rudman, which Jim will remember, because I thought that if we did away with it, we consolidated everything under the president in the executive branch, you could probably save significantly, probably something like 20% of the combined budgets of the two agencies at least. Not surprisingly, even though my counterpart at the FTC was a noted conservative, he didn't like that idea. So it's oftentimes very hard when you actually talk about hitting home to get people to acknowledge that. I've also talked in the past about maybe, we don't need a Section 2 of the Sherman Act. When I made that point to the Antitrust Modernization Commission, I was chastised roundly, ironically, by Google's outside lawyer. So it's kind of interesting how these things play out. But the fact is, that's not going to happen, okay? So the law is what the law is, and the question is, how do we implement it? How do we enforce it? And to me, you have to understand the nature of what the antitrust laws are. It's what we tried to do in the Reagan administration. First, you have to design rules that essentially acknowledge and explicitly incorporate the costs of applying the rules. And a rule's no good if it costs more than the benefits it achieves. And so it's important to keep those costs in mind. The rules need to provide clear ex-ante guidance to business so that businesses can understand how the laws apply and incorporate it accordingly in their implementation and their planning. That also, frankly, is not a very popular position with the bar. I mean, one of the things we like to say back in the Reagan administration is we tried to provide guidance that business people could understand, even without consulting their lawyers. The ABA didn't seem to like that position. I don't know why. Then specific enforcement should be based on facts, not theory. And prospective efficiency should be given at least equal weight to prospective anti-competitive effects. There's a tendency in agencies to be biased against prospective efficiencies and in favor of prospective threats. And I think they have to counter that. However, the rules need, and this is the important point, the rules need to be based on neutral, objective principles applied non-discriminatorily. They can't really be based on subjectivity. They can't be based on who happens to be popular or who happens to have contributed more to the particular administration in power. And it can't be based on superficial political sloganeering. Antitrust enforcers, as Jim said, are not very well suited to pick worthy and unworthy companies. If they start picking and choosing, am I going to apply the rules to this company but not to that company, you're going to have all kinds of distortions that are very problematic. So antitrust enforcement really has to be even-handed, or in the old saying, justice has to be blind, and that's the best way, I think, to minimize distortion and prevent the abuse of the antitrust laws. One of the points that I've made before, and I should say that all my comments are for me, even though I do represent various clients, and I'm also opposed to some, including Google, so I'm going to address this to Google, but this is my own personal view. If you look at some of the people who are today supporting Google and saying, gee, you shouldn't apply the laws to them, they're the same people who were most out front in terms of arguing back in the 1990s that the antitrust laws ought to be applied to Microsoft. And, at the time, I was fighting that proposition. I lost. The courts, conservative D.C. Circuit, established the rules. They're there now. And so one should always be wary of people who at one point have said, yeah, you really ought to sock it to that other company, but then when it comes to them say, gee, no, don't apply it to our company. To me, the rules have to be applied non-discriminatorily, and they have to be applied even-handedly. The focus, as we used to say back in the old days, needs to be on market structure. Remedies should be structural to the extent they can, and behavioral remedies should be used sparingly and probably only in circumstances where you're talking about unilateral behavior, and then even those should be based principally on thou shalt not. The cases should also be based on precedent. I mean, I agree with Jim, just because there's a precedent out there doesn't mean you bring a case. But I do think that in enforcing the law, you need to be sure that there is a sound basis in the law. And then second, and this is one of the places where I think I do have a little bit of a disagreement, maybe a lot of a disagreement with this administration, I think it's important for the administration to go into court to enforce the law. I think one of the problems with antitrust is far too much gets resolved outside the courts and not subject to judicial review, and that's a real problem. I think an example of that is, for example, criminal enforcement, where the amnesty program and the threat of somebody rushing in first and getting a better deal has led lawyers not to defend their clients so much more, but to try to work out a deal with the government. And some cases have developed, I think, that are not altogether worthy. Section 2 is another area where I think the law has been established. Microsoft was the battlefield for resolving a lot of questions. They're resolved. Now they need to be enforced even-handedly with respect to other companies in the industry. And finally, mergers, the one point I'll make, and this is kind of going, and I'm going to sit down, I promise, goes to Bob Skital. And Bob says none of the cases, and he's right, none of the cases that were, or all the cases that were brought today would have been brought in 1982. I'm not sure that that's exactly true, but I will say in the horizontal area, the fact is there are deals that are allowed to go through today that would never have been allowed to go through in the 1980s. I think that's a good thing. I think it's a reflection of an understanding of a lot of the things and principles that I've discussed. So that's a good good news that the system is working. The bad news is a lot of it is happening within the administrative agencies, not in the courts, and that's not, I don't think, a very healthy thing for a statute that, at the end of the day, is regulatory.
Thank you very much, Rick. And now, to bring it on home, the Honorable Ronald Cass. Ron, please.
Well, I don't have as much to disagree with in Rick's comments as I'd like, so I'll disagree with things he didn't say rather than things he did. I'm going to start out. Rick did say in the beginning that no antitrust regulator likes to think of himself as a regulator. And I know that when I was in Washington in the government, one of my friends was a social scientist and used to study government, said no government official likes to think of himself as a dummy variable. But the importance of that was driven home to me when I was giving a speech in St. Louis. And the fellow introducing me said, and now for the latest dope from Washington, here's Ron Cass. Antitrust, of course, is regulation. I think Rick is right and Jim is right about that. A senator recently stood up and on the floor of the Senate said that the federal and state agencies enforce antitrust laws in order to forestall the need for burdensome regulation. And I think that's like saying we drown witches to avoid the need for burning them. You know, it's clearly antitrust is a form of regulation. It is not distinguishable in any major way from any regulatory device. The real question is how good or bad is the regulation. When Bob Skitol was up here, Bob said, not all regulation is bad. And I was struck by that because I spent a lot of time in academia in Massachusetts, where the only seriously debated question was whether all regulation was good, not whether some of it or all of it was bad. In the antitrust case, there's a lot of reason to think that a great deal of antitrust enforcement is bad in practice, even if it is defensible in theory. When Rick was talking about the difference between horizontal and unilateral conduct, between group conduct that restrains competition and acts by a single company that may have achieved some measure of market power, I think he was drawing the line in the right place, because it is fairly easy, not totally, but fairly easy to identify a range of conduct among companies where coordinated activity can very well restrain competition in ways that are reduce consumer welfare and reduce national welfare. And we've identified a lot of them over time. A lot of this enforcement is done actually in court, and a lot of it is subject to rules that even if we have some argument about how they apply in a given case, by and large, the rules are well known and fairly easy to apply. It's simply not the case when we get to single firm conduct. We talk about firms that are dominant and that use their dominance in ways that restrain competition. And that's a great phrase, except that it's very difficult in practice. All of you, I'm sure, are familiar with the thermos conundrum. You know, the thermos keeps hot things hot and cold things cold, but the question is, how does it know which are which? In the antitrust area, in the Section 2 category, in the dominance area, the real question is, how do you know what is bad behavior and how do you know what is good behavior? We have a lot of history here of bad behavior being described in theory, but when we get to actually apply it in practice, we tend to be guided by the supposition that whatever company is dominant in whatever sphere is going to stay dominant for the foreseeable future, and that whatever its actions are that seem to disadvantage rivals will interfere with competition and harm consumers. And I'd like to take a minute to talk about those two assumptions because I think neither one is right, and I think they tend to be fairly destructive as a practical matter when it comes to antitrust enforcement. The first one is the notion that a company that is dominant is going to stay dominant. We almost always see that applied by enforcement agencies at just the wrong time, in just the wrong place. And let me take just three quick examples here. In the 1960s and 1970s, the Department of Justice was ginning up for three big investigations. And they were trying to decide whether to bring cases, antitrust enforcement cases, under Section 2 against three targets. The first one was IBM, which was dominating the computing market. And the people in justice realized that mainframe computing was the only form of computing that was going to matter for the foreseeable future. And they found actions by IBM that they thought, particularly some tying arrangements that IBM had engaged in, that they thought restrained competition and would keep IBM in control of the computing market forever. Of course, they brought the case, they filed it in 1969 on the last day of the Johnson administration, and managed to bring the case just before personal computing and mini computers revolutionized the computing world and substantially eroded IBM's position in computing. The second case was the AT&T case, which didn't get filed until 1974. It was predicated on the theory that landlines were the only form of telephony that really would ever matter. And of course, this case was filed and brought and argued just before cell phones revolutionized the way we communicate by telephone. The third case that was undertaken was started with an investigation that began in 1963 and was seriously debated at the Department of Justice, was the case against General Motors for monopolizing the car market. If you turn back the clock in the 1950s, approximately 1% of the domestic car market, sales in the market, were supplied by foreign labels or foreign imports. And the people at DOJ realized that imports would never be a significant factor in the U.S. market. They didn't bring the case because they decided they didn't have the manpower to bring that many large cases at once, but you run the clock forward and you see IBM is diminished substantially in terms of its position in the market. AT&T is out of the market. Its name still is there, but the company actually no longer exists. And GM went from being the dominant car company to being essentially bailed out by the government. So we have a real problem of foresight, and it's a problem that is especially trenchant in the high technology space. We have vigorous competition in high technology. Look at the dominant companies today. Look at the companies that are the targets for antitrust action. There are companies like we've heard Google mentioned, also Yahoo and Twitter and Facebook and Amazon. And most of these companies didn't exist. Apple, most of these companies didn't exist 10 or 20 or 30 years ago. It's a dynamic space with a lot of innovation, a lot of invention, and the more we do to try and rein in the leaders in the field, the more we discourage investment and innovation, the more we risk taking steps that harm the American consumer rather than helping. And I will end with just one observation. One of my friends is married to a psychiatrist. He says this gives him endless trouble when they're going to arrive somewhere. Anytime they arrive late, she says he has avoidance issues. Anytime they're early, he's compulsive. And if they're on time, he's obsessive. The same strategy can be applied to antitrust cases. Thank you very much.
Thank you very much to each of the panelists. We have a fair amount of time open for cross-communication and also for questions from the floor. So let me encourage the panelists to direct some questions and comments to each other. And in that spirit, let me start the ball rolling by asking Bob and Rick, dial the clock back to the 90s. The search market on the internet. Should that have been a topic of attention for the antitrust officials? And would that have been a regulatory attention or a non-regulatory attention? And then do you think that that we have to have a theory about the rate of change in that industry, then or now, in order to answer that question? Or do we get to not worry about innovation and rate of change? In other words, are Ron's examples colorful but not relevant to the question of whether there should have been attention?
I don't believe there was a basis or a reason for antitrust attention to the search market or the search space during the 1990s. There has come to be antitrust interest in recent years because one firm called Google has achieved what looks like a pretty dominant position over that space, and there have been complaints and that Google has been misusing its dominance in ways that threaten monopolization of complementary markets, and so the FTC has got a fairly broad investigation going on. Google is cooperating with it, and we'll see what the outcome ends up being. We've come a long way. Our antitrust authorities, both the FTC and DOJ, have come a long way since the 1970s and the IBM debacle and so forth. We've become a lot more sophisticated in distinguishing between lawful and unlawful conduct on the part of a dominant firm. We still haven't gotten everything right. But both agencies throughout the past couple of decades have been very selective in its targets for Section 2 type cases, and the law and the thinking in this area continue to evolve. And I don't think there's a problem with over-regulation. There have been very few Section 2 cases in each of the past several administrations.
Let me start by answering it this way. Look, I will stipulate to the fact, and it's certainly important for regulators to understand, that markets are dynamic, okay? You know, one of the things that Bill Baxter used to always talk about is the fallacy of constant slope. I mean, nothing, people who project based on what they currently see today and assume that it's going to continue forever, 100 times out of 100 are going to be wrong. And there's no question that, that industries change, and, that cases that may not have made sense at one time could make sense, and then later on might not make any sense at all. I mean, I'm reminded that at a time when I was a young lawyer full of vim and vigor, and remember, I'm the guy who gave the speech on deregulating antitrust, and I think one of the best antitrust articles ever written is Easterbrook's The Limits of Antitrust. And, you can make the argument that even cartel behavior, even OPEC, and I made it at one time, why do we have to worry about it? Because eventually, market forces will break it down. And there's no question about that. But I was reminded, there's a lot of costs sort of in the meantime. And what antitrust is really designed to do is to be applied to deal with those problems. And so, for example, in the two of the examples that Ron gave, yes, it is true that by the early 1980s, PCs had replaced mainframes. But in 1969, and really all through the 70s, there was no alternative to mainframes. The reason that Bill Baxter got rid of that case in 1982 was because by that time things had changed so much. But that's not so much a condemnation on the fact that the rules maybe should have applied to IBM or not. It's a condemnation of the way in which the court and the agency went about dealing with it. Similarly with AT&T. I mean, ultimately, wireless communication became a relevant factor, but it was 30 years after the case was brought. I mean, nobody would have said in 1980 that cellular or wireless communication was really an answer. Those arguments only started being made in the 90s and really were fully accepted in 2000. So the question is, okay, does that mean that the behavior that was stopped for ultimately Bill got the settlement in 1982, that there was some benefit to that? I think the argument is, yeah, there probably is. And finally, look, the big argument in the Microsoft case, or one of the big, conceptual arguments was, is antitrust just too cumbersome and anachronistic an implement to deal with high-tech industries? Because frankly, you couldn't have made a case against Microsoft until certainly the early 1990s, okay? And one of the arguments that Microsoft made is antitrust is too cumbersome, it takes too long, you really ought to let the market work. Well, no less conservative and august body than the D.C. Circuit, and probably Doug Ginsburg writing for the D.C. Circuit, recognized that that's really not an excuse for not enforcing the antitrust laws. It's a reason to look at the rules and the tools that you use to implement it. But it simply says, okay, we've got to scale the tools, we've got to design the tools with that reality in mind. But it shouldn't give people a pass just because their monopoly may be ephemeral and may not last forever to do whatever they want. I mean, after all, Microsoft did have a position and still does have a position of fair significance. And while it's true that it would have been ludicrous to go after search in the 1990s, because there was no search in the 1990s. I mean, it wasn't until 1998 that Brin and Page wrote their famous piece. And it really wasn't until probably 2002, 2004 that there'd be any reason for a concern. But the simple fact that there wasn't a reason for concern in 1990 isn't a reason to say, gee, we shouldn't be concerned if they're not adhering to the law today. If they're not adhering to the law today, and that is resulting in either them achieving a dominant position or extending that dominant position, then there is probably reason to be concerned, particularly since the rules that they may be violating are the ones that they so vigorously argued for in the 1990s against Microsoft. So I guess I don't see that that's a very good defense, and to the extent it was one that Microsoft made that they poo-pooed and successfully in front of the D.C. Circuit. Now they got to live with it. That's the law, and the simple fact that markets are dynamic is not an excuse for not enforcing the law.
So maybe just a quick pause point. As moderator, it's always hard to know whether even weighing in is immoderate. And so I guess I'll just notice for us all to look up later whether, it seems to me there are some fact questions in what Rob and Rick have talked about, because I think their answers, if I heard them correctly, basically hinged on, in part, two factual statements. There really was no search, or there was no dominance in search in the 90s, and there was no one complaining about that dominance. So I guess we just all have homework to do to figure out whether actually Yahoo existed at that time. My recollection is it did, but I could be wrong.
It wasn't a search engine, though.
And it maybe was doing some search, and maybe not, and maybe people were complaining, and maybe they weren't. Those are fact questions, and we're definitely not going to resolve those here without a record. So let me ask, I guess, just all to reflect on that for later. The moon could be made of green cheese, too. I can't verify that, but I do think that, look, I mean... My guess is the folks at Yahoo don't think of themselves as having not existed, whereas I don't know of anyone who's going to presently stake the green cheese moon flag out.
Well, I think if you ask Yahoo, just look, I mean, it's important, whether you're the moderator or anybody else, Yahoo would not say they were a search engine in 1990. What they had, the way they started was they compiled lists of websites, which is very different from search with algorithms. So now you could say, if you're saying that search, then okay, but that's not the way anybody, including the Bush administration, has defined search. But it just didn't exist then. But even if it did exist, even if you could say that Yahoo was there, the simple fact that things changed and Google became dominant, the fact that it wasn't a problem in 1990, I don't get how that's an argument for not enforcing the law when it's violated in 2000. Doesn't make any sense to me, but I don't know.
I think the problem is that you're framing this in a way that is attractive to the side that is bringing cases, but misleading. It's not a choice between enforcing the law and not enforcing the law. You have a law that is highly ambiguous, that depends on a series of facts that are not obvious on the face. And and you live in a political environment. All of us on this panel have been in position where we are government appointees, government officials, and we know that while we never think we do things for political reasons, there are political pressures. The complaints that are brought by businesses that have a stake in the outcome, just as the defenses are from businesses that have a stake in the outcome. As Rick says, and rightly so, businesses are often not very constant in their theoretical arguments. They tend to be moved by what helps them at the time, and politicians tend to be similar. They tend to be moved by the businesses located in their jurisdictions or contributing to their campaigns or otherwise sympathetic to them, who have pressure that is brought to bear there. If we had a set of rules that were clear and determinate, it would be one thing, but we don't, and we don't have facts that are clear and determinate either. And the only other point I would make before I let you have back at this is that the developments that are over the horizon for the regulators aren't always over the horizon for the businesses. The businesses, Microsoft was worried about Google. Google, I'm sure, is worried about Facebook. Facebook, I'm sure, is worried about Twitter. I'm not young enough to know what Twitter is worried about. But the businesses are, in fact, worried about competing for the generation of technology yet to come. And the fact that it hasn't developed already, hasn't been implemented already, doesn't mean that it doesn't constitute a constraint on the business.
Now, look, that's absolutely, I don't disagree with that, Ron, but here's the question I guess I would ask you. I mean, you know, I believe that you know, you can decide you don't want to have the law, okay? And as I say, I mean, it's ironic because probably in the room, I'm the only person who's ever been bold enough to say, get rid of the law. Now, but I guarantee you, not only am I the only person bold enough to do it, I'm probably the only person here who would vote for that. So it's not going to happen, okay? The law is there. And if the law is there, you got to expect people are going to adhere to it. And unless you tell me that Microsoft was so wrongly decided that it's not good law, and that the precedents that, you know, that were articulated there, the lines for analyzing whether conduct was legal or illegal when it was unilateral conduct, and the statement by the D.C. Circuit that yes, the law can deal with dynamic industries. It needs to recognize that, but it doesn't mean that it should abstain from enforcing the law. Unless you can tell me you disagree with that opinion and the precedent, it seems to me your position is a very difficult one. Because what you're saying is, look, Microsoft should have won. Maybe I believe that because I made those arguments. Maybe you believe that because you were making the arguments with me. So you're very consistent. But the fact is, we lost, okay? And the law is what the law is. And the worst kind of regulation is regulation that is based on subjective decisions about, I'm going to apply it to this company, I'm not going to apply it to that company. Now, it may be that Google hasn't violated the law. It may be that on the facts they can say, hey, this isn't a problem. But simply saying, we're not even going to look at the facts, we're not going to see whether or not they violated Microsoft because that's established precedent, because, oh my God, maybe they won't be here in 10 years, maybe they wouldn't have been here in 1990, I just don't think is a reason for giving people a pass on their obligation to adhere to the law and the importance of applying the rule of law generally, even-handedly, and non-discriminatorily.
Okay, Bob and then Joe.
So I agree with Rick. I think it's important to distinguish between two different things. One is, do we object to dominance in and of itself? And the answer is no. And second, do we object to abuse of a dominant position in a way that unlawfully maintains the dominance or prevents newcomers from coming along to challenge the dominance, or that allows monopolization of complementary markets? Nobody, so far as I know, has ever seriously argued that Microsoft unlawfully obtained a dominant position. The whole DOJ case against Microsoft was about specific exclusionary acts and kinds of exclusionary conduct that were challenged as unlawfully maintaining its monopoly power by preventing companies like Netscape and Sun from developing technologies that would enable new competition and operating systems to rise up. In a similar fashion, nobody, so far as I know, has seriously argued or has seriously made out a convincing argument that Google has unlawfully acquired the dominant position that it now has. The whole concern about Google, or at least the serious concern about Google, is whether, and what as I understand is the heart of the FTC investigation as it's been publicly aired, is whether Google has been using its dominant position in search in ways that discriminate against smaller competitors in complementary markets, and that would enable whether the algorithms that Google has constructed for its search business bias the search displays to present Google products and offerings to the disadvantage of rival offerings, and whether that kind of bias, if in fact it exists, has an exclusionary effect and threatens to enable Google to monopolize not the search market but other adjacent markets. That's what it's all about, and that's a totally appropriate inquiry under Section 2 of the Sherman Act and Section 5 of the FTC Act.
I'd like to agree with Ron and also my former colleague in the Reagan administration about the need for transparency and for making rules and regulations as simple and as straightforward as possible. And let me give you an example. Rick, you probably like this. A couple of months ago, I had dental surgery, and I was prescribed a bottle of this stringent mouthwash. And I went to the I live out in Little Washington. I went to the local pharmacy, and I got this. And on the label, it was printed something to the effect, "Put cap full in mouth, swish from side to side, then expectorate." The pharmacist took one look at me and my bumming around clothes and knock around clothes and baseball hat, and he slapped another label on there that said, "Swish in mouth, then spit." We need a lot more of the swish in mouth and spit kinds of laws and rules and regulations than the expectorate and all that. The second thing I want to take issue with Bob here and say that the notion of abuse of dominance, first of all, dominance is a pejorative word. I tried to avoid that when I was at the FTC. You might account for a certain percent of the market, but it doesn't mean you dominate, because dominance tends to imply that you took some action to make it. Now, I know, Bob, you suggested that was the case, but I just am concerned about that word. You can have a problem, or a firm can cause a problem in an industry if it has monopoly power. But I ask you to consider whether somebody like Google, in this case, would have monopoly power. One, the consumers are very sophisticated. Very sophisticated. Number two, let me ask you, how many of you have more than one search engine, just for example, one or have more than one search engine on your computer? I do. Well, in that event, you don't even have to download the search engine to change. You just click another search engine. I mean, switching is extremely easy and low in cost. And as you know from Price Theory 101, that it's the switchers that make markets. And so it seems to me that given the low cost of making these choices, it's very unlikely that Google has monopoly power here, and that would be our concern. And that's one reason I think that it's misguided to go after Google in this case.
So let me just,
One point on that.
well, just one sec.
Okay.
Let me just encourage participation by the audience, that if you would like to participate, raise your hand, try to get my attention. I'll put you on a list and then make sure that we direct the microphone over to you.
Jim Calderwood back
So
there.
we're going to get the microphone moved over, see if that will generate a question that you could maybe tether your response.
Well, but I think, oh, well, okay.
Sure, go ahead.
But let me just, the point that I think sometimes gets lost, and I think it was lost a little bit in Jim's statement. Remember, the Bush administration, Bush 2, was prepared to go to court to challenge Google for monopolization in their Yahoo deal. But the markets that they were defining were the market for search advertising and search syndication. And if you look at those markets and you look at the behavior of advertisers, you will see that Google's share is extremely high. And if you talk to advertisers, they will tell you that that Bing, really Ad Center in the United States, the only alternative, is really not a good substitute because of its scale and because of what Google has. So the fact is that the issue is, usually follow the money is a good idea. If you look at search advertising, and you look at search syndication, and you have to look no further than Bush 2, they defined those as markets and found and believed that Google had monopoly power in that market. And that's really, I think, where Google should focus its arguments, not on the other side of the market, which is how consumers are attracted, although that is part of the story.
Please. We have a microphone, and if you could, there we go.
Okay. Nobody's ever had to give me a microphone before because my voice usually carries. But Rick Rule was talking about legislative changes, and no one in the panel has mentioned a problem I see in antitrust with the private treble damage actions. Usually what you see is the class action coming along in the antitrust case. That's not going to be dictated in any way by public policy. It's going to be people seeking the money from the treble damage. And it forces companies to very often enter into settlement agreements when they don't really believe they've done anything wrong. But because of joint and severable liability, they could be facing hundreds of millions in possible private damage actions, or they could settle right now for a much lesser sum. And so my question, Rick, to you or to anybody on the panel is, has anybody been looking or would favor seeing some limitations on the private treble damage actions, particularly as they have been used in abusive ways in the past?
Yeah, the only thing I would say really quickly on that, obviously there was a lot of focus on that in the 1980s. We actually had reports, we were supporting legislation that would have de-trebled antitrust to some extent. And it probably is still a good idea. I mean, I don't think what we were proposing was bad. On the other hand, a lot of things have happened since then. Matsushita did happen in the 1980s, but then you had Twombly, which, has in a way kind of affected a sea change in private antitrust litigation. The development of standing law has dramatically dealt, with the problem. To some extent, the biggest issue are the follow-on cases, so maybe that's a concern, but that may be a concern in part because a lot of those cases are started by amnesty applicants where again, I think there are cases that are being brought today, or people are going in and getting amnesty, where there actually would be pretty good defenses, and 20 years ago, those cases would have gone nowhere, and would have gone nowhere fast. But
Ron?
I think Rick is right that there is a change in the law in a lot of ways that reduces the problem, although there's still academic writing about it. And I think there is still a problem with the follow-on cases, which means that whenever a government gets in, there's a sort of echo of what sort of suits are going to go in the wake of the government action. But I did also want to pick up something that Bob and Rick had said. Bob had talked about there being sort of a perfectly legitimate inquiry to be had, and Rick had said, essentially, we have rules, we ought to enforce them even-handedly. And I think while it's undoubted that we ought to enforce rules even-handedly, when the rules have a high degree of ambiguity and are highly fact-dependent, you're not going to have any way of being perfectly even-handed in enforcement. And the other problem you have, and this responds to Bob's point, is that there's a cost to the inquiry. Anytime you start an inquiry into a company where there are potential consequences in terms of injunctive relief and in terms of treble damages down the road, you have an impact on the company's behavior, and you also have an impact ex ante in terms of the expectation. So you have to worry about this. I don't think anybody would propose that you have a special carve-out for anyone. I think what people are proposing is that you have skepticism about deploying remedies that are uncertain and intrusive.
okay, I think that's fair, but beyond that, I guess the problem is, and it would be helpful to me to know tangibly, what do you think how does that manifest itself? One way one of the things you could say is, gee, the DC Circuit ought to go back and reconsider what it said in Microsoft. I don't disagree with you that obviously if something is fact-based, it can't be even-handed in the sense that it applies identically regardless of differences in circumstance. But the real question is whether or not the same rules ought to apply. And a lot of the arguments that you hear sometimes from Google, things like, well, it's our search engine, so we should be able to do whatever we want to with it. It doesn't matter what impact it has on competitors and things like that, are arguments, frankly, that Microsoft made, that AT&T made, and others. And, there's a famous line in the Microsoft case about, yes, you have a property right in a baseball bat, you can own it, but that doesn't mean that you have freedom to use that baseball bat however you want. And I kind of think that's right. And so the question is, so given all that, what are you suggesting? Are you suggesting we just leave Google alone, we don't look and see whether or not they violate the law?
I don't know.
So very, very brief, and then we have a question from the audience.
My suggestion is whether it's Google or Apple or Facebook or Twitter or Amazon or Yahoo or any of the companies that have been potential targets or actual targets recently in the high-tech space, I think that the antitrust authorities ought to be very skeptical about jumping in to start cases against them when you have a dynamic industry, you have an awful lot coming along, you have a lot of IP investment that these companies are built on. So there's a dramatic amount of competition in the IP space, as well as competition for being the next development.
Let's just jot a note and then work that into our next response.
I want to find his answer.
I have spent quite a bit of time trying to sort out this dominant firm Section 2 stuff, and Ron, I was in the middle of the Justice Department during that period you describe, GM, which I wasn't in favor of bringing a case, IBM, which I wasn't much of a fan of, and AT&T, which I was a big fan. And it seems, the question I've got for the panel, doesn't it help you to draw a line between what one might call on one side legacy monopolies that are, of which there are a great many more in Europe, that are created by either state action or overwhelming economies of scale sustained over a long period of time, and innovation monopolies like Google and Facebook. And isn't one of the problems we've got is when it comes to creating rules to deal with legacy monopolies, we really get into a problem when we try to apply them to innovation monopolies where the world is changing much faster. And finally, the last thing I would say, Ron, about the AT&T case, it was concerned with a lot more than the telephone line to the consumer, the last mile. It was concerned with the confusion and cost of having the telephone company also the supplier of the rate-based regulated equipment, and the use of long distance as an internal subsidy device, which would be eliminated by competition.
Hey, Don, just before you stop, because the one thing you didn't mention was Microsoft. And the interesting thing I find up here is the guy who was defending Microsoft against people like Don was, I don't think you could call Microsoft a legacy monopoly.
I did.
So, right, but you were suggesting that action should be taken. So the question is, has your thought process evolved, or, what's curious is a lot of these arguments are being made by people who were sort of in the forefront of arguing that Microsoft ought to be condemned, and now you're essentially adopting those arguments after the D.C. Circuit came out a different way. So I'm just curious as to how that happened.
So
Maybe trying to figure out how different Europe and the United States have been, whereas the United States, the government has mostly been involved, with the exception of AT&T, in dealing with innovation monopolies. And Europe has been mostly involved in dealing with legacy monopolies like Deutsche Telekom.
And Microsoft.
I don't think Microsoft is a legacy monopoly.
we just need to keep the conversation going here.
I think the distinction between legacy monopolies and what we think of today as dynamic, high-tech monopolies is not that clear-cut. If you look at Microsoft, for example, Microsoft has had a solid monopoly over desktops for more than 2 decades. Google has had a dominant position in search for almost a decade. And look at a company like Facebook, innovative, dynamic, high-tech, so forth and so on. Well, if anybody doesn't think, if anybody wants to argue that Facebook does not have some degree of enduring market power today, then you've got to explain how a company that made about $1 billion last year is about to be worth $80 billion. That says something about enduring market power, even in what we think of as high tech today.
Jim?
Could I say I agree with Don's characterization? There's a difference between legacy monopolies and so-called monopolies or dominance in the IT sphere. In part, you could just think it simply, legacy monopolies, the market will eventually erode the monopoly power, but it may take a very, very long time. In the IT sphere, monopoly power is eroded very, very quickly. The other thing, and there's a parallel here, and I think Don would agree with it, you're much more likely to find real monopoly power, true monopoly power, in industries that are regulated by the federal government or the state governments, or who have been insulated from competition by the power of the state. So I would agree with that point. Thank you.
Let me try some other broader questions for everybody on the panel as we, maybe if you each think to yourselves 2 minutes or so of wrap up, and maybe consider these questions as you get ready to have that wrap up, which I'm sure will inevitably involve some back and forth. So number one, for multi-firm conduct, and you think about mergers, and you think about the cost of mergers, and you think about the role of antitrust activity, whether it's regulation or not, it's activity. Is it the only activity in the merger space that we should be thinking about? So, for example, today on Wall Street, a lot of people will tell you the ARBs can't find enough M&A deals to ARB. Is that because of activity in antitrust, or is that because of activity in securities regulation and other areas that we think of as corporate law, not antitrust law. So that would be one broad question for everybody to think about. To what extent is antitrust the only tool to be thinking about for multi-firm activity, or should we also be thinking about corporate or other areas of law? Similarly, for even single firm activity, should we be thinking about intellectual property? So, Rick, you pointed out that there's a 10-year delay in the 70s before IBM gets replaced by competitive desktop computing. It's worth noticing that it was IBM that led the charge in the Justice Department in the 1960s, 1970s, that culminated in the 1972 Benson decision in the Supreme Court that decimated patent protection for software. Patent protection was decimated for software through the 70s and early 80s, and that was when we started to develop a single large software company, Microsoft. So the IP shift in the law was actually at around the same time that you're directly targeting. Should we be thinking about patent law or other forms of IP law as it interacts with antitrust? And then the third overarching question, absent from this conversation so far, has been a focus on conduct at the FTC. So the Federal Trade Commission has targeted the IP antitrust interface pretty specifically, beginning with its 2003 report and all the way up to its 2012 RAND report and its hearings, 2011 RAND report and its hearings this past summer on RAND and FRAND. Do you think that's an area where we're having the right amount of activity, too little, too much, too blue, too green, what have you? So let's move down the line. Those are all three very broad questions, but see if you want to touch on any of them. Rob.
I'll start with the merger area. I think antitrust gets a bum rap.
Just into the mic.
I think antitrust gets a bum rap for interfering with merger activity. I think it's grossly exaggerated. Each year in the past several years, the FTC has challenged somewhere between 15 and 20 mergers in a given year, almost all of which are settled with a surgical divestiture, and DOJ has challenged and settled a similar number. That's as against hundreds and hundreds of mergers that go through HSR and are early terminated or the waiting period ends at the end of 30 days. So all in all, it's a tiny, tiny fraction of total merger activity that gets bothered by antitrust at all.
Jim?
With your permission, I'd like to ignore the questions you ask and just make make a comment that this may be a parochial view. When I was in high school, my friend Joe Cornwell put together a little computer with relays he called the EDIAC, and went to the state science fair. When I was a kid in college, I remember seeing the copy of Popular Electronics that had on the front that very early computer kit. I wrote a dissertation at the University of Virginia and had an algorithm which used the entire core of the Burroughs B5500, and I had to use all of my operating during night when professors weren't using the computer for their time. And the computations on that machine could be accomplished on my Mac, in just a few seconds, and it took 43 minutes to run the program. I remember the TRS-80 that I got, my wife's Atari, and I remember the cell phone. I had a brick at OMB. Man, I was stepping in high cotton. The progress made in that space has been phenomenal. And I think it's because there hasn't been the heavy hand of government. And it's important that whenever you tamper with something that's very successful, you be darn sure you know what you're doing. And that's one reason I come at so much of this as a skeptic for the government's initiatives.
Rick?
Where were you in 1995 when we needed you, Jim? I think the couple of things I would say about mergers, I'm not going to say that there aren't mergers that are, that business folk call off because of antitrust today, but my sense is that phenomenon is pretty rare. I mean, most business people, if you can put together a sensible merger, they employ lawyers to figure out ways to get it through the regulatory process, and it's pretty rare that something dies on the drawing board. There are a few deals that sometimes get stopped, the AT&T T-Mobile is an example, and that's worthy of a whole program on its own. But by and large, antitrust is not a showstopper these days, and there are other factors that are at work. With respect to patents and antitrust, that's always been a really important interface in terms of laws over time. I think it's reemerging as an important one. Microsoft, for example, views itself as an IP company. I think the critical issue right now is what's happening with IP in the mobile platform space and the use of so-called standard essentials patents that I think Bob talked about. And how that all plays out, and whether or not companies that have made FRAND commitments in a standard-making process can then, in effect, use those patents to exclude competitors from the marketplace. I think there's a pretty good argument that that is a problematic set of behaviors. Whether or not the antitrust laws ought to deal with it, I don't know. But I do think that that is a critical area coming up. And those are issues that the agencies are looking at, and I don't think that's an illegitimate place to look for the future.
Well, I've spent a lot of time dealing with antitrust, intellectual property, and international trade, which used to be three separate fields. It's now one amalgamated field, and I'm happy for that because it finally gives me the opportunity to focus on one thing. I did want to say that Don's question was a good one, and that you're right that we have a different set of things that affect us when we have government in there regulating, and AT&T was different. But one thing that isn't different is when you look at the actual claims and you look at what happens with the claims. In the AT&T case, as you remember, we went from having a predatory pricing claim to a claim that wound up being pricing without regard for cost. You wound up having a motion made to dismiss the case because that didn't state a claim on which relief could be granted, and Harold Green said, I'm not going to rule on that, I'm going to wait for the parties to settle it. In the Microsoft case, one of the early claims that was brought was, and this is one of the parts of the early FTC investigation, was a complaint that Microsoft's contracts with OEMs, original equipment manufacturers, did not all expire on the same date. And that was viewed as something that raised rivals' costs because they couldn't show by, all at once having the opportunity to get in there and replace everything, that they could be a suitable alternative to Microsoft. Of course, if all the contracts expired on the same date, that would raise rivals' costs because then they'd have to replace all of them at once. We have a series of claims and theories these days which allow enough flexibility to make almost anything a leading firm does potentially a violation of antitrust laws. So I would suggest caution. I noticed that Rick said that one of his favorite articles was Frank Easterbrook's articles on the limits of antitrust. And by and large, what Frank was doing was saying, here are ways of looking at things, here are screens and filters you should use before you bring these cases, and you should be especially cautious when you deal with areas like IP-driven areas, like intensive dynamic industries. You should be very careful about those industries and those cases and think long and hard before you bring them.
All right, well, we've come to the hour. This is clearly a topic on which there is going to be a lot of open debate and dialogue, so we just want to encourage more of it. Please join me in thanking the Federalist Society, its Corporate Securities and Antitrust Practice Group, Dean Reuter, the Practice Group Director, and each of our distinguished panelists. Thank you all very much.